Welcome to today's discussion. The topic of today's discussion is on consent as a general exception. Sections 87 to 92 of the Indian Penal Code deal with the defense of consent. Let's understand Section 87. Section 87 provides for an act not intended and not known to be likely to cause death or grievous hurt, done by consent. The code provides that nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause, or be intended by the doer to cause, to any person, above 18 years of age, who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Let's see an illustration based on Section 87. A and Z agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which, in the course of such fencing, may be caused without foul play, and if A, while playing fairly, hurts Z. A commits no offense. Section 87 protects persons engaged in the ordinary games such as boxing, football, cricket and the like. The game should be played fairly and there should not be any foul play. By virtue of Section 87 of the Code, an act done by a person is not an offense if the following conditions are satisfied. 1. He should not have intended to cause death or grievous hurt. 2. The person to whom hurt is caused should have expressly or impliedly consented to suffer harm or to take the risk of any harm. 3. The person consented to take the risk should be above 18 years of age. Let's understand Section 88 of the Indian Penal Code. Section 88 provides for an act not intended to cause death, done by consent in good faith for person's benefit. Let's see what code provides. Nothing, which is not intended to cause death, is an offense by reason of any harm which it may cause, or be intended by the doer to cause, or be known by the doer to be likely to cause, to any person for whose benefit it is done in good faith, and who has given a consent, whether express or implied, to suffer that harm, or to take the risk of that harm. Let's see an illustration based on Section 88. A surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under the painful complaint, but not intending to cause Z's death, and intending, in good faith, Z's benefit, performs that operation on Z, with Z's consent. A has committed no offense. By virtue of Section 88 of the Code, an act done by a person is not an offense if the following conditions are satisfied. 1. He should not have intention to cause death. 2. He should have done the act in good faith for the benefit of the person who suffered harm. 3. The person suffered harm should have given express or implied consent to suffer the harm or to take the risk of that harm. Let's see what Section 89 says. Section 89 of the Act provides that an act done in good faith for benefit of child or insane person, by or by consent of guardian. The Code provides that nothing which is done in good faith for the benefit of a person under 12 years of age, or of unsound mind, by or by consent, either express or implied, of the guardian or other person having lawful charge of that person, is an offense by reason of any harm which it may cause, or be intended by the doer to cause or be known by the doer to be likely to cause to that person. The Code also provides for some provisos in Section 89. That this exception shall not extend to the intentional causing of death, or to the attempting to cause death. That this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death, for any purpose other than the preventing of death or grievous hurt, or the curing of any grievous disease or infirmity. That this exception shall not extend to the voluntary causing of grievous hurt, or to the attempting to cause grievous hurt, unless it be for the purpose of preventing death or grievous hurt, or the curing of any grievous disease or infirmity. That this exception shall not extend to the abatement of any offense, to the committing of which offense it would not extend. Let's see an illustration of Section 89. A. In good faith, for his child's benefit without his child's consent, has his child cut for the stone by a surgeon knowing it to be likely that the operation will cause the child's death, but not intending to cause the child's death. A. Is within the exception, inasmuch as his object was the cure of the child. Section 89 of the Code also provides for an exemption also. That is, guardians from criminal liability when they give consent for minor under the age of 12 years of a persons of unsound mind. The guardian giving consent to suffer a harm to his child is not liable for any crime if he has consented in good faith for the benefit of the child. Let's see what Section 90 provides. Section 90 of the Code provides for consent known to be given under fear or misconception. The Code provides that A consent is not such a consent as is intended by any section of this code, if the consent is given by a person under fear of injury, or under a misconception of fact, and if the person doing the act knows, or has reason to believe, that the consent was given in consequence of such fear or misconception, or consent of insane person if the consent is given by a person who, from unsoundness of mind, or intoxication, is unable to understand the nature and consequence of that to which he gives his consent, or consent of child unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. By virtue of section 90, consent given by a person is not consent if given under the following circumstances. 1. If he has given consent under fear of injury or under a misconception of fact. 2. If he is unable to understand the nature and consequence of his consent due unsoundness of mind or because of intoxication. 3. If he is a minor under the age of 12 years. Let's see what code provides on acts done without consent. Section 92 of the code provides for act done in good faith for benefit of a person without consent. The code provides that nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith, even without that person's consent, if the circumstances are such that it is impossible for that person to signify consent, or if that person is incapable of giving consent, and has no guardian or other person in lawful charge of him from whom it is possible to obtain consent in time for the thing to be done with benefit. The code also put forward some provisos. They are that this exception shall not extend to the intentional causing of death or the attempting to cause death. That this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death, for any purpose other than the preventing of death or grievous hurt, or the curing of any grievous disease or infirmity. That this exception shall not extend to the voluntary causing of hurt, or to the attempting to cause hurt, for any purpose other than the preventing of death or hurt. That this exception shall not extend to the abatement of any offense, to the committing of which offense it would not extend. Let's see some illustrations based on section 92. Z is thrown from his horse, and is insensible. A surgeon, finds that Z requires to be trepanned. A, not intending Z's death, but in good faith, for Z's benefit, performs the trepan before Z recovers his power of judging for himself. A has committed no offense. Z is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Z, but not intending to kill Z, and in good faith intending Z's benefit. A's ball gives Z a mortal wound. A has committed no offense. A surgeon, sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is not time to apply to the child's guardian. A performs the operation in spite of the entreaties of the child, intending, in good faith, the child's benefit. A has committed no offense. A is in a house which is on fire, with Z, a child. People below hold out a blanket. A drops the child from the housetop, knowing it to be likely that the fall may kill the child, but not intending to kill the child, and intending, in good faith, the child's benefit. Here, even if the child is killed by the fall, A has committed no offense. It is to be noted that mere pecuniary benefit is not benefit within the meaning of sections 88, 89 and 92. By section 92 of the code, an act done in good faith for the benefit of a person without consent will not be an offense. In order to apply section 92, the following conditions should be satisfied. 1. The person done the act should have acted in good faith. 2. It should be intended for the benefit of the person who suffered harm. 3. The person to whom harm was caused should be incapable of giving consent due to minority, insanity or unconsciousness. That's all for today's video. Subscribe for more videos. Visit our website for MCQ examinations and notes on this topic. Happy learning! A video from Law Aspirants Hub.